Hello, Assalamualaikum. Good afternoon, ladies and gentlemen. Welcome back to MFPC TeaTalks, where we discuss various topics focusing on financial planning. I'm Najiha, your host for today. So today on the show, we are excited to have Tuan Haji Rafie Omar, advocate and solicitor, and MFPC Syariah registered financial planner. A little background of Tuan Haji: he was enrolled as an advocate and solicitor of the High Court of Malaya in March 1989, and also a Sharia lawyer at Selangor Sharia Court in 1992. Afterward, he joined Malaysian Resources Corporation Development Berhad in 1994 as a legal advisor in its Business Development and Corporate Affairs divisions. And in year 2000, Tuan Haji was with Dana Harta as a legal advisor for the property division before joining Amanah Raya Berhad in 2001 as general manager, operations, and subsequently as GM sales and marketing. And starting from 2007 up to 2012, Tuan Haji was the CEO of Amanah Raya Legacy Services Sendirian Berhad, a wholly owned subsidiary of ARB, doing estate planning and intestacy services. And during 2013, Tuan Haji set up his whole legal practice and give regular talks on Islamic and conventional estate planning and estate administration to government departments, training institutions, state Islamic departments, private sectors, institutions of higher learning, and public forums and seminars. Wow. Tuan Haji have a lot of experience. I bet today will be going a long sessions. So today, Tuan Haji Rafie Omar will share his expertise on asset distribution, trust versus will. Assalamualaikum, Tuan Haji. How are you?
Waalaikumsalam warahmatullahi wabarakatuh, Naj.
Alright, I hope you had your lunch already.
Yes,
how are you?
yes, alhamdulillah. It was a good lunch, and I hope we are going to have a good tea session. TeaTalk
sessions, yeah. So to our participants, while you enjoying our session today, you can prepare cup of tea or coffee to enjoy the sessions. So Tuan Haji, since I have already introduced you a little bit of your background to our participants today, so maybe I can, if I may ask, how long have you been in this industry actually?
Well, I've been involved with MFPC, if that can be considered as financial industry, financial player, since the inception. At that time, I was the general manager, sales and marketing of Amanah Raya, public trustee. So Amanah Raya was involved in financial affairs, financial services. So MFPC invited Amanah Raya to become one of its corporate members. So since then, I have been with MFPC, say more than how long?
20 years.
Nearly 20
years.
Nearly 20 years. Yeah. Okay, that's long time.
Almost my age.
Okay, all right. Okay.
Alright, and then what makes you decide to be in the financial industry?
My expertise is in legal. I was and still a lawyer, but when I was with Amanah Raya, my job scope involved financial advice, and most of the time on the estate administration of our clients. There I realized that from whatever I was doing at Amanah Raya, trying to settle estate administration of deceased people, I realized that a lot of Malaysians don't have proper estate planning. Right, so I pursue this objective, my jihad, to create awareness of the importance of estate planning for the general public, because based on my experience, people always put aside or what you call as they procrastinate in planning, because estate planning is like a taboo. People don't discuss this issue because people busy giving all attention and effort for the accumulation and protection. On the distribution, people still lack awareness. So since I was at Amanaraya 2001, I've been giving a lot of awareness campaign, giving some education of the importance of estate planning, particularly because based on my personal experience as a lawyer, 1994, at that time I haven't even joined corporate. I was still a practicing lawyer in Kuala Lumpur. I had very rich client at that time. He was very rich. To illustrate or to show, to indicate how rich he was at that time, he was one of those people in Malaysia at that time, 1994, driving biggest car in the country lah. Mercedes SEL 380, that kind of thing, big car. So not many cars at that time in Malaysia, so he was one of those owners. He's a very kind person, generous person. I was handling his legal matters, particularly on his claim on his land, some court cases in Kuala Lumpur. So he's a kind person because he likes to belanja people, so he likes to share. As a lawyer, I was very happy lah. He will come to my office. My office was right smack in town, in Jalan Melaka there, near Masjid Jami'. So he will drive from PJ to pick me up, take me to court, drive me to court, and then drive me to land officers or whatever. And then he will stop at a place where there will be good food. So he likes to eat. And then, as I said, a generous man, this fella, whatever we eat at the restaurant, he will tapau. He will bring back, make sure we bring back. So I remember asking him question, we have eaten enough, why must we take tapau? Now he will say that, whenever we eat good food, we must also remember that, our family would like to taste the same. So that's why, so every time we eat, say, good food, we also bring home. So it's very generous. So this man, one time, this is a personal experience I want to share with you all, why I am involved in this estate planning. So one fine day, after I won his court case, we succeeded in one of his claims against whoever sitting in vacant land. We managed to kick them out. So we at a place, that time was very famous lah, Krishna Curry House, that kind of thing. So we sat there. While eating lunch, I know he's going to tapau. Then he asked me a question. Rafie, tell me, what car is a good car for my son? That was his question. What car is a good car for my son? So I said, whatever car you buy will be a good car. I said, why? Because, ladies and gentlemen, he said that his son is celebrating 18th birthday. So I said, okay, if that is the case, I propose that he buy for his son on his 18th birthday gift, Toyota Corona 1.8 SE. A good car at that time. So he asked me why. I said, you driving 380, your son can drive 1.8 lah. Then I asked him this particular question. So ladies and gentlemen, this is a real personal experience. So I asked him a question. I asked him, say his name we take as Mr. Lim lah. I said, Lim, you want to buy a new car? You want to buy a new car for your son? How are you buying it? Cash or hutang? Hire purchase. He said, Rafie Chinaman we don't buy car cash, all hutang. So you all can confirm that lah, hutang. So I said, then I said, okay, hutang you have to make sure you have proper planning. So I said, anything happen to you, who's going to settle the loan? Yeah, new car, your son is only 18. Who's going to settle the loan? His income at that time was not less than 20k, 1994, 20,000 net on itu, not less than, most of the time more than that. So minimum 20. So I said, anything happen to you, what's going to happen to the car? That time he scolded me. He said, Rafie, we are having lunch. We don't talk about death. Sui. So it is a taboo. So I stopped. I didn't say anything else. We complete our lunch. On the way home to my office, and on the way back to my office, near my office, say 5 minutes before we reach my office in Jalan Malacca, I again asked him. I said, sorry, Lim, just now I asked you a question, but no, I have to repeat this question. You carefully plan. Make sure no, you have some protection. Make sure your son is not going to be left with that big loan. He scolded me again. And he said, Rafie, driving time also you cannot talk about death. I said, oh. So I kept quiet. So I learned at that time, it is taboo to talk about death when you're having lunch, when you're eating, as well as you're driving. So I understand that situation. Unfortunately, about 1 or 2 weeks later, Mrs. Lim called me on the phone, wanted to speak to me, and asked me, Rafie, Mr. Lim got do will or not with you? I said, why? You asking me whether Mr. Lim has done his will with me or not? And the answer is no. Even when I talk about his plan on buying the car and talking about this, he said no, it's a taboo. He scolded me, so he hasn't done anything. So I asked, why are you asking Mrs. Lim? And she said, Mr. Lim passed away yesterday. So ladies and gentlemen, from there on, 1994, even before I joined this MFPC 1994, when I was a lawyer, before I joined corporate, I faced this predicament. People put aside on planning, estate planning, and consider that it is not important, it is taboo, until such a sad situation. And until now, ladies and gentlemen, I do not know what actually happened subsequently, because I was not contacted again. Post check, I do not know what happened to the family, but I embark on that time. Whoever I meet, I want to make sure that they have some kind of estate planning lah.
They need to have the proper planning.
Proper planning, yeah, inshallah.
Like you have been in this industry for many years, and the example that you just shared with us just now, it seems like even since 1994 and up to 2023, we are almost to 2024. There are still people with the ideas of, I'm not rich, I don't need the estate planning, I don't have that much money, or I don't have that much asset to have for the future. So I guess that is the biggest challenge that you have had during your time.
Yes.
So, how are you tackling years by years that
the
mindset are still there?
Yeah, alhamdulillah. I'm the frequent speaker on the subject. Whenever MFPC, for example, having organize meeting the people, awareness campaign, I'm in the forefront, creating awareness. Some of the platform, I'm invited for the past 15 years. I've been invited by this particular government department. They have a regular, every year they have what you call as pre-retirement training program for their staff who are going to retire in the following year. So I've been invited, and there while people talk about retirement planning, financial planning, health planning, I come in and also share the effect if they don't have proper planning. So I ask them, make sure that they plan properly, they have some kind of protection, that kind of thing, and regularly, both for the Muslim side and for the non-Muslim side, and I'm also alhamdulillah involved in training the professional. We train the professional whenever they are sitting for their RFP or Sharia RFP, registered financial planning, organized by MFPC. I'm part of the training unit, and also for other training institution. We also go and talk to youngsters, people in the university. We train the lecturers as well as create awareness for the university student for financial planning, and part of financial planning is estate planning. So alhamdulillah, and today we're gonna have a very important topic for us to differentiate between wills and trust. I hope this session will be beneficial to all of us, inshallah.
Right, inshallah. So can we continue to our next alright, okay. Before that, I need to ask you one more question.
Yes.
Before I forgot. So I mean, like you said, you have been since 1994. There are some people who are still denying the estate planning, and then even up until today, you continue to spread awareness to make even the youngsters as me, just like me, to understand the importance of estate planning. So, what was your first win? Your first win that you decide that that you confident that you were doing the right thing in estate planning?
Oh, okay. Alhamdulillah. We can bring the horse to the water, but we cannot force the horse to drink the water, right? But alhamdulillah, from the record, there is proper record actually to show that people are now getting more awareness. When I was with Amanah Raya as GM operation, subsequently general manager sales and marketing, and later becoming CEO of a special company wholly owned by Amanah Raya to go and organize estate planning via will. And of course, after that we execute the will, intestacy administration, estate administration. There's proper record to show that now, from only 18 when I first started, in 2004, when I first started going on campaign to create awareness, there were only 18 number of wasiat for Muslim at Amanah Raya at that time. Okay, now we have more than 1 million registered wasiat will at Amanah Raya. So the record speak for itself lah. So it really from zero, from zero to hero lah. So there are more than 1 million wasiat and will now registered with Amanah Raya. Even after I left Amnare, the number keep on increasing, alhamdulillah. And this show that people are having awareness, more awareness. So much so that sometimes when you want to talk to a person, on other tools of estate planning, they say, I have my wasiat done, so that's it. When you want to talk about other tools, say for example, asking them to do trust, asking them to do hibah. No. We have got our wasiat written, and later we will touch, if we have time, that though there are awareness, but sometimes the awareness can also lead to some confusion, right? So the Muslim, when they are aware of the importance of a wasiat, they write wasiat to their own heirs, right? Giving in the wasiat to heirs. When for the heirs we know that the heirs or waris will inherit through hukum fara'id or their family settlement, but they write a will, they write a wasiat, which might not be consistent with the proper requirement. If we have time, later I will touch that for the Muslim, wasiat is for non-heirs, right? Wasiat is for non-heirs. So my job is still not complete. It's still, I still have to go on and then explain. People now are much more aware of the importance of wasiat for the Muslim, for example. But probably the wrong way they go and organize this. And for the non-Muslim, people are much aware of the wills, the importance of wills. But today, perhaps we will also touch later that why you want to give via will when you can give directly while you're still alive, right? So this is the purpose of our sharing session today, insyaAllah. Okay, so we will organize that while we wait for the technical issue.
Technical issues on the slides. Anyways, just now that you said about hibah, right? So I think people nowadays, when the person in charge of agents, insurance agents or whatnot, trying to tell them the importance of hibah, most of people, they run away from it.
Yeah, correct.
I have some friends who work in this industry that we have some talk session, sharing sessions, and they said like it's not the people who have been working, even the youngsters, when they said about hibah, it's not important, they said. Yeah. So what are your comments about that? Okay,
for the Muslim, hibah is giving while you are alive, right? Hibah means give intervivals while you are alive. Therefore, if they have nothing to give, so that's why it's not important, nothing to give. Inshallah, we will touch on that later. I have got already a question.
We only 23 minutes in, and we have 2 questions already for Tuan Haji, but it's okay, you can keep on asking questions. You can ask either at the live chat or at the Q&A section. We will get back to you once we finish our once Tuan Haji finish with his slides today.
Okay.
So we are going into the discussions topic today. So Tuan Haji, maybe can you explain a little bit to our participant what is asset distribution actually in a nutshell?
Okay, alright. So ladies and gentlemen, I'm going to share, if it is available, I'm going to share the slides on your screen. If the can we organize?
Okay, can you guys see? Alright.
Okay, so ladies and gentlemen, when we talk about asset distribution, okay, on your slide, we have this very important issue to consider. Okay, now the topic for today is trust or will.
Correct.
So this is one of the tools, or 2 tools of estate or asset distribution. Right. So whenever we talk on this point, asset distribution, we always have to remember the 5W and 1H. 5W is the who, what, where, when, why. The 1H is how. Now, ladies and gentlemen, we will be able to answer or come to some clarification if we ask ourselves, the what. So later on the screen now you have I put a slide for us to share. Wealth accumulation, wealth protection, wealth distribution is part and parcel of financial planning, right? And the estate planning, as you can see on the slide, is on the the tip, on the top, what do you call it, paramount, on the top of the list. And it says that these are 6 areas of the comprehensive financial planning. We illustrate those areas in the form of pyramid to show how one area build upon the other. So if you talk about your financial position, you talk about your protection on managing the risk, how you want to invest in the accumulation of your asset, your wealth. You must also plan for your taxes and zakat for the Muslim. You also have to consider when to retire. But last but not least, the most important thing is to make sure that you consider the distribution of your wealth, and that is called as estate planning. So, ladies and gentlemen, estate planning is not only about real estate, not about rubber estate, not about oil palm estate and whatsoever. It is about wealth accumulation, wealth protection, and wealth distribution. Okay, so the slide shows, sometimes people talk about real estate only, but it is much more than that. Even if you have a house, right, you have a responsibility to make sure that the real estate will be inherited. So you must have a proper planning. On the other hand, ladies and gentlemen, there are this common mistake in wealth and legacy planning. When we talk about wealth distribution, people have no estate planning. Right? So this is the danger. People have a lot of way to accumulate, to invest here and there, new what you call as fintech coming out, people helping us to make it easy for us, and then we protect, we take insurance in takaful, but we do not have proper estate planning, and this is the cause of the issue. So when we consider that 5W 1H just now, so the question we ask, what is estate planning? Right, so estate planning, ladies and gentlemen, is defined as the process of making appropriate arrangement, underlined, for the protection, preservation, and provision. So this provision is what we call as distribution of a person's asset for the benefit of the dependents, not for his benefit, for the benefit of the dependents and other beneficiaries. Right? And here on your screen, the slide says, these are the objective. The objective is to minimize the cost of estate administration and providing maintenance. And of course, if you have proper plan, you will avoid dispute among the heirs, beneficiaries, and a proper management of your asset. So the tools, when we talk about asset distribution, there are tools. So on your screen, ladies and gentlemen, we have these tools, estate planning tools. So if you haven't done any one of these, you make sure that you have properly done. Now on your screen, ladies and gentlemen, I am sharing with you, there are various tools. What I underline is for the Muslim. So underline is Muslim or in Malay. But for conventional one is the one without the underline. So nomination, for example, number one, nomination. So it applies to both Muslim and non-Muslim. When you want to give your endowment for the Muslim, it is called wakaf. When you want to give charity, for the Muslim we call it sedekah jariyah. When you want to do trust, for the Muslim it's called amanah. Gift, just now we mentioned hibah, gift. Wills, wasiat. So whenever I say wasiat, it means for the Muslim. Whenever I say amanah, for the Muslim. But for non-Muslim, I will quote the English version, wills, for example. And you have expressed wishes, you call it as nazar. So these are the tools. I will show you examples how these tools have been organized. For example, this one I read in sometime in March in the newspaper. Ex TV actor Lee Long Kei, 72 years old, right, transfers 7 properties to 36-year-old girlfriend. Transfers while he is alive. So that is called gift. Gift inter vivos. No issue. No, don't have to wait. Just give. That's why the girl is smiling away. Receiving a gift from the boyfriend. Next, this is what you call as charity. Veteran actor CYF, Chong Yun Fat. This is when I was younger. This is great actor. Okay, he donates his asset worth 3.3 billion ringgit. Say it's his wife's idea. This is charity. Not giving to anybody, but giving to charity. I didn't want to donate it. It was my hard-earned money, he said. But the wife, who was very kind, make sure that this is done. This is reported recently, as recent as 7 October 2020. This is to show you, this is charity just now. This is wills. On your screen, ladies and gentlemen, now I have this wills. Right? And the recent story about wills. Hong Kong star Karina Lau reportedly leaving 450 million, our billion fortune to her nephew. The star reported this in May 20th, 2022. This is wills. When we talk about will, we'll see that it is postponed to the time of death. It will be executed upon death. Next, I also have this Malay Mail reported recently. Singer Joyce Cheng get 33 million inheritance from late mother, actress Lydia Sham, after turning 35. Only when she turns 35, she received the money. This is based on the wishes of the mother. We know this. When I was younger, I grew up with this movies by this actress lah. So ladies and gentlemen, then you ask me, why Rafie are you referring to Hong Kong kind of thing? So ladies and gentlemen, the Hong Kong society, meaning the jurisdiction in Hong Kong, the people in Hong Kong, they are much more advanced than Malaysia. They understand this importance of having plan much earlier than us. The rate of penetration for financial planning, estate planning is much higher than us. Say, if you go to Hong Kong, you meet 10 people, you can have 5 people having proper planning on their wealth, because they are rich people. But in Malaysia, you talk to 10 people, maybe 1 or maximum 2 having done. So this is our mission. We all involved in this. We want to go and educate people. So I compare this with Hong Kong, because Hong Kong has got a lot of issues as well, and because they are quite open about this, so there are cases reported. Also on the screen, ladies and gentlemen, if you see, this is wills, right? One of the tools that being used. Princess Diana's home will be inherited by dia punya young actor, not William. The young actor actually is the nephew of Princess Diana, not the son, no William, no Harry. Okay, because they are going to be king later. So Diana planned so that so by that, when we see the example that I showed you on wills, no, this is the definition of a will as defined under Wills Act 1959. So because what is will, you refer to the Wills Act. I want to highlight, ladies and gentlemen, Wills Act 1959 is applicable to non-Muslim only. So for the Muslim, be aware, you don't follow wills, you do wasiat, and wasiat has got different rules. So it defines a will as a declaration intended to have legal effect of the intention of the testator with respect to his property or other matters which he desires to be carried into effect after his death. I have underlined that, after his death, and includes a testament, codicil, or an appointment by will or by writing in nature of a will in exercise of a power, and also a disposition by will or testament of the guardianship, custody, and tuition of any child. So ladies and gentlemen, that's the definition, proper definition in the Act. So now we know that with a will, you decide who, just now we question of 5, who will benefit, what, when, how much from your estate. So a will takes effect after the death of a testator. So the law specify that it shall be in the form of writing. It must be, this is the requirement, right? This is a requirement, must be in writing, must sign or put thumbprint, and it must be at the end. The law says it must be at the end, not on top. Testator must sign in the presence of at least 2 witnesses, and the testator, whoever makes the will, when he signs, the 3 of them must sign together in front of each other. You cannot have the testator sign and then later the 2 witnesses, because the confirmation by the witnesses that we sign because we see the testator sign the will. And very important, whoever become the witnesses cannot be the beneficiaries. So if you want to give to beneficiaries, that beneficiary should not be the witnesses, because if he also sign or they also sign, these 2 witnesses sign, but they are also named in the will as the recipient of the asset, then the part on recipient fail. The will is still valid, but the part on they cannot become the beneficiary. So ladies and gentlemen, this is very important. That's why we must know the basic of a will, because we want later, as the topic suggests today, which one is better. So we have to understand will first. So the main purpose of a will is to express the testator's declaration as to the disposition of his asset, of his property. So he must state, must express clearly what's going to happen to the property. Then the other purpose is who wants to execute that wishes. Whoever is appointed in the will to execute, he is named as the executor. If a female is appointed, she is called executrix. Agak-agak Najihah, do you know the difference between executor and executrix? Why they change the name? This is just a joke lah, because tricks, mean the female has got a lot more tricks than the male. So the tricks okay, this is just a joke. It's just not to differentiate executor, executrix. Now then, in the will you can also appoint the trustee. Maybe the same person or maybe another person. And that's why, very important, later we will see that you can also create a trust via a will. So it is not actually different. It can be, the trust can originate from a will. So we have to understand that later, but when you create a trust via a will, that is called as testamentary. It is in your testament that you give somebody, I say I appoint Syed Khalil, a good friend of mine at MFPC, very learned person, so I appoint him as the executor for my estate. You are the recipient, the beneficiary, and I say don't give everything to Najiha because she is still very young. So give, annually. So whatever I leave behind now will be put into trust for the benefit of Najiha alone, for example, subsequently. So that is called testamentary. So ladies and gentlemen, there are other purpose that you can include, for example, how you want to be buried. And I did a real case. This case is very interesting to me. When I first joined Amanah Raya, one of the first job that I did was to become Amanah Raya, to become executor of Amanah Raya. The corporate body can be appointed as executor. So we were appointed executor. We want to execute a will of a retired British soldier who came to Malaya at that time, to protect the independence. When we during the confrontation with Indonesia, this man came to Malaya, and then he fought in the war, and then he decided to stay in Malaya, and he became a good person with some asset that he had. So he prepared a handwritten will. The writing was also in italic, italic pen, so very nicely written. And he, in his will, he said that, this is, I still remember, he said his body must be cremated, common, and he said, and the ashes to be put into an urn. Okay, so the ashes after cremation put into an urn, and that urn will be sent to a place known to his staff, which means he has already informed his staff to be sent to a place known to Pak Abu. So his staff named Pak Abu. So after his death, I think that was done by the organization. So I wanted to make sure that the will has been properly executed, including the last line, last paragraph. So I asked Pak Abu. So I said, Pak Abu, itu Abu si mati, Pak Abu sudah hantar ke mana? Pak Abu tahu where to be sent. So he was stunned. Abu si mati, Pak Abu hantar ke mana? So because Pak Abu was the person entrusted to do it. So you can do that. Peculiar wishes. There was a movie lah, bucket wishes ke whatever, to you can see people have the requirement, the wishes listed. So ladies and gentlemen, okay.
Sorry. So when you were talking about handwriting,
yes.
So there's actually a question from Kuat Haso. There are people promoting handwriting their own will, because actually we don't need a lawyer or trustee to write a will. So what is your advice on this?
Okay, very good. This is quite important, very good question. You can write your own. I wrote my own but I don't use handwriting. I type. In the case of just now, that man written by that italic handwriting, but you can type it yourself. You can go Google and see samples A lot of example can be given. You can do it on your own, but it must be step by step. And then when you sign, you need 2 witnesses. In my case, that's what I printed. I signed in front of 3 witnesses actually. My wasiat. When I did my wasiat, one male and 2 females. Because for the Muslim, 1 male equivalent to 2 female. So because I don't have another man, I have to look for another 2 women to become my witnesses. For the conventional one, you have 2 witnesses. Anybody, 2 female pun boleh. 2 witnesses. So when you sign, make sure you have 2 witnesses. Baru the will become valid. Date is at the end, as I said just now. You can follow. But this is my real experience as well. I encountered a real will written by a deceased person, of course printed lah, sign, witness, everything. But there were 2 things lacking in that valid will. It is valid will, but list of asset, properties not stated, not included. All my properties, that kind of thing. So not specified. So no specific instruction on specific item. Next is this man forgot to name the executor. So when you don't have executor name in the will, because you do it yourself, you forgot that you have to appoint executor, and then it cannot be probated. It won't be considered as testacy. It is partial testacy, meaning it is half intestate, half testate. You cannot apply for probate in court. You go to court and apply for LA. LA with will annex, meaning the administrator will be the one appointed by court, not appointed in the will, because it is not written. That's why you can do it yourself. You can Google. You can also ask people from MFPC how to organize and what they will do. They will send that question that you send to them to me, and I will answer. So okay, the answer to that question is okay.
Ask again, what happened if people only open the will after settling the funeral?
It is okay. It's okay. For
it's not related to the estate.
Yeah, correct. Most of the time, that's what happened. You only take out the will and read after
the funeral.
But if the funeral has been carried out, macam mana? Nangis lah, that one special requirement cannot be done. That is why actually for our non-Muslim friends, they don't cremate, they don't do. They have funeral, wake 3 days before the funeral, that kind of thing. So maybe that's the time for the heirs to read the will and see if there's any special but sometimes, most of the time the wills are executed later lah. But not all wishes in the will will be carried out. Some you cannot do it later. That's why the idea is when we talk about financial planning, and then the definition is about just now is about property, his property. People who wants to do those who want to do will must ensure that it is about the property lah. Not something else. In the will you say please go and box sign Khalil, for example. That should not be carried out. Correct or not? So that thing sometimes be carried out or cannot be carried out. So if that's why on the screen now, ladies and gentlemen, you can see when there is a will, there is a way. So it is about your requirement. So it is merely the wills are merely tools for estate planning. Estate, what is estate? We have to go back to the original definition. When you are alive, all assets are yours. When you are not around, those assets now become estate. So that's why it is about property, about your asset. I always question people outside there, what happened when there is no will. So I will always start with this one. So if you see on the screen, the article was on the same day, from the same newspaper, The Sun, 18 February 06, 2006, long time ago. But the sharing is very important. If you have, but if you don't have, what you do? You must go on and take advice. So, ladies and gentlemen, do you want to answer? Tak payah. I see one question. It says that what are the minimum content in a will so that a will won't become void? So just now I mentioned, in the definition, it is already there. You must date it, and the date must be clear, and you must sign at the end. Because, ladies and gentlemen, I did a real case. Now there was say 2 pages of a will, but say there are 20 paragraph. The signature was on paragraph 9. Was at the end of paragraph 9. Then you come paragraph 10, paragraph 11 until paragraph 20th. But the signature on the top, at on the middle at paragraph 9, not at the end of paragraph 20. Therefore, there is void because it is not in accordance with Wills Act. Okay. Now that I mentioned that, I want to highlight that for wasiat, on the other hand, such a requirement does not exist. Because for Muslim wasiat, you don't need to be in writing. It can be orally when you have 2 witnesses. So there is no requirement on. It must be at the top or the end, right? Correct. There must be 2 witnesses. But if you do a proper written wasiat, then you follow the recommendation, you sign, you put your thumbprint at the end of your written wasiat. So must comply with the format. If you go into the will, you can download Malaysia Wills Act 1949. Okay, 49 or 59, I can't remember now. Okay, you download lah, either 5th or what? I forgot actually now whether 59 or 49, but I'm sure it's 59. Right? You Google that, in the act, there's also sample given. The format. Now, ladies and gentlemen, now on your screen, I want to highlight this. Inheritance Family Provision Act 1971. On top, you see that generally Malaysia know the importance of having a will, but most are still putting off writing one till now. Only 10%. Just now, this is probably 2 years after the 2008. This statement. Jadi 2010, okay. Now, which means the penetration rate is low. That's why I gave example from Hong Kong, from Singapore. Later I'll show you. Because here the acceptance penetration rate is still 10, maybe now 15. So if there is a will, there is a way, my friend said. But he also highlight that this. Under this Family Provision Act, Inheritance Family Provision Act 1971, allows 4 categories of dependents to apply to court to vary the will for their maintenance if testator has not provided sufficiently for them. So I give you an example. Say my name is Jonathan Rafie. I write a will. Say I write a will. I have wife, I have 3 children, I have 2 old girlfriends lah. Say for example. So I don't provide for my wife, I don't give enough, I don't give to my children, I give 50% to girl number 1, Mrs. number 1 or Mrs. number 2. I can do that. I can do that. No, they get more than my own family. So when the will is to be probated in court, my wife, depending on me, right? Say her name is Mimi Rafie, my surname Rafie. She, dependent wife, not married, widow, can go to court and ask the court to ensure that the will to be varied, meaning the court will order that the wife will be given sufficiently. Okay, next, son below 18. The son, if they are still below 18, they can be represented by the mother to claim for maintenance, schooling and everything. Or unmarried daughter below the age of 40. So this is unmarried daughter below age of 40. She can go to court and say ask the court to vary because she is not married. She is below 40 years old and she was dependent on the father. Now the father gave to other people, right? She can claim. Next category is istimewa lah, special, OKU, special need children. Does not matter the age, and they can go to court because they relying on depending on the estate of the father, and now the father don't leave anything, only very little. They can go and ask for the proper maintenance. So these are the 4 categories of people who can go to court to vary. So I hope ladies and gentlemen, you understand this requirement. Therefore, most of the time it is important for the testator to write in the will why he is not giving, to these 4 categories of people. You must state the reason, or otherwise normally they will put, I give to my wife 1 ringgit only from my estate because I have given her enough during my lifetime, and she has a fixed deposit under her own name of 1 million, for example. Then she cannot claim anymore under the wasiat, to vary the wasiat. So this is very important. You must state the reason why you are not giving. So while just now, just to add to some answer to the earlier question, yes, you can write on your own, but either you make mistake or you may be doing something which is not regular. So that's why you want to engage the service of a lawyer. And not all lawyer can do this, right? You go and see the lawyer who's experienced with this, so that you can be properly advised. Okay, all right. So, ladies and gentlemen, the reason why you have to engage a proper consultant, probably estate planner trained by MFPC kind of thing. We do train what you call as professional estate planner, right? Program, PEPA, something like that. So at MFPC we organize this training. Those who are not sure can check with MPC. We train this professional estate planner program. Why? Because you must understand that a will in itself is of no effect, right? A will takes effect upon death. How you want to give effect to a will? You have to go to court and apply for probate. So on your screen you will see that what happens during probate process. This is the process. You have to authenticate the last will. You appoint the executor, whoever. Then you go. No posting of bond. No, bond is for LA. So you, identifying, notifying the creditors. You determining all the values of the estate, and then you locate the estate, and then you pay whatever required before you distribute. Before you distribute the asset. So this is the requirement. So a will in itself will not be effective until you get probate. So to illustrate further, say now we have a Mat Saleh. This Mat Saleh reside in America, say in Seattle, Washington. So on his way from Seattle to Australia, he stopped over in Malaysia. Probably he has some sweet time here, and then so happened, meet Rafie, organized with Rafie for his will. So all the assets are in America. A few assets in Australia, nothing in Malaysia. But his will is written in Malaysia by Rafie. So he signed good witnesses. As long as that will written in Malaysia is valid under Malaysian law, that will is valid in America, is valid in Australia, valid for the purpose of getting probate. So the court in Seattle will issue probate. With the probate, the heirs in Seattle can go to the banks, can go to the financial institution, organize the transfer of property in Seattle, nothing to do with Malaysia. Similarly, if he has some property in Australia, right, the will that was written valid in Malaysia will be valid to be probated in Australia, depending in which state. So Victoria, for example, they see the will is prepared by Rafie Omar. Melbourne train. I'm also capable. I can practice law in Victoria State. Because I passed the law from Melbourne University of Australia, right? So I can practice in Victoria Court, Supreme Court of Victoria. So that will be considered valid for the Supreme Court of Victoria in Melbourne to issue probate. Then with the probate, they can organize the asset, the estate in Australia. So that's why I said just now, very good that question. You have to get professional advice. You do it yourself, and if you are really great. Even on the screen now, ladies and gentlemen, I'm showing you.
Okay, have a drink first.
Have a drink, TeaTalk, right?
TeaTalk.
TeaTalk. But I'm drinking plain water now. So, ladies and gentlemen, on your screen, Lee Kuan Yew's will. Kwa Kim Lee to face disciplinary tribunal. Yahoo.com. Okay. You can. So the complaints against Kwa Kim Lee Center conduct in the handling of Lee Kuan Yew's will were raised by Lee Hsien Yang left and Lee Weng Ling right, the younger sibling of Singapore's Prime Minister Lee Hsien Loong. So, ladies and gentlemen, even the greatest, smartest person in this side of the world, the late Lee Kuan Yew, the former Prime Minister of Singapore, the will was prepared by the niece. This Kim Lee is a niece, a great lawyer as well. But for some reason, there was dispute on the will. Though prepared many times, amended, prepared new one, and then signed, and then prepared a new one by Kim Lee. Kim Lee got into trouble, because of the complaint, and she was actually fined, quite some hefty thousand of Singapore dollar, tens of thousands of Singapore dollar for some misconduct. What it says here. Kuan Yew pay 13,000 penalty Singapore. over misconduct in relation to wills. So, ladies and gentlemen, on your screen you can see Lee Kuan Yew's lawyer ordered to pay 13,000. Why? Because, ladies and gentlemen, because some dispute of over an asset. Right? And this is this year's report, May 2023, problem. So as I said, Singapore jurisdiction, and in Singapore people are well versed. If you go to just now I mentioned, if you go to Hong Kong, you see 10 people, 50%. You go to Singapore, probably more, probably 60% have got will. Probably, I say, there's no proper record lah. But they are very well advanced in this estate planning. But as latest as 1st of November, I am sharing with you, ladies and gentlemen, from the Star, from the star.com. Doctor's widow, eldest daughter, lost court tussle over Singapore 4 million will to all 4 kids. Very interesting case. And this doctor had a lot of cash. He was a very old doctor. He was running his own clinic. A lot of money for that matter. So he prepared a will and then give all to 4 kids. But at the same time, he changed the bank signatory checking account to manage the account, appoint the wife and the eldest daughter. So the eldest daughter and the wife, upon his demise, thinking that they were the owner of the whole estate because they are signing, but the court has got proof. It is proven in court that the will was not changed. The will keep intact, even though the will was amended after the change of signatories for the account. The contents of the will was not changed, giving to 4 kids only. Very interesting. So if you can, ladies and gentlemen, you can capture this screenshot and then later go into this website and read. Very interesting. So as I said, when you prepare a will, this sometimes can happen. You have to go through a process of probate, and during the probate, dispute may arise. In Singapore, actually, in Hong Kong, in Australia, as well as in the UK, when you want to get probate, you don't need lawyer to be present. It is what you call a summary, registrar's duty. Say my name is Johnny Wilkinson, for example. Johnny Wilkinson. Johnny Wilkinson is a great rugby player for England. Okay, so this one, Sion. Johnny Wilkinson. I live, say, in Birmingham. Okay, I prepare a will with proper consultation and everything under the Institute of Professional Will Writer, IPW, UK, based in Birmingham, of which I was a former member. I was trained in Birmingham to organize proper will for the UK, so that's where I was trained. Say, this man is Johnny Wilkinson. He had a valid will prepared by a member of IPW from Birmingham. So when he dies, so the family members need not engage lawyer. Just file the application through His Majesty's Court now, family court. File the application and then go through the process. Within a month or 3 months, probate will be issued. No need to go through a lawyer. Similar with Singapore, similar with Australia. Hong Kong, I'm not sure. But in Malaysia, just now I said you have to go to probate, right? You have to go to court, right? Lawyer will have to represent you in court. Lawyer will have to come to court and show. And then when it is in court already, by the time it is in court, it is your inheritance, what you have and everything become public matter. because it is in court system. No, anybody can check.
Check, yeah.
So that's why now, we on your screen, ladies and gentlemen, we want to differentiate the difference between will and trust. So on the screen now, main difference, we have a will goes to effect only after you die. But when you die, then everything will be shown. People can see it from the public domain. Trust takes effect as soon as it is created, but nobody knows. Right? So if I have created trust in favor of my colleagues in MFPC, right, the trustee will keep secret. Nobody knows. So that's the main difference which we are going through. We have enough time or not? Yes, we have plenty of time, inshallah. Okay, anything that...
So before
any question? Yeah.
There's a question from Marlene. He asked, if the testator wants to give extra to heirs via wasiat, what are the ways to go around it, since Tuan Haji has mentioned that wasiat is meant for non-heirs?
Okay, very good question. Ni this form wasiat,
Yeah.
I think Malin is our always follow us in our session. Yes, so ladies and gentlemen, if you want to give more, you don't do via wasiat. That's why we have hibah just now. You just give. While you are alive, you give. For the Muslim, it's called hibah. Similarly, for non-heirs, you have family. I mean, for non-Muslim, you have family. Your heirs will be for a non-Muslim. You have your parent, your spouse, your children. That's your heirs. Right? They are all present. You want to give more to your brothers and sisters. To avoid any unnecessary dispute later, while you are alive, if you can give, you give. That's what we're going to show later. If you want to give more to your children, right, you can provide under a will for non-Muslim. But it is better to do so while you are alive. And I have last slide to show how it can be effected. But now we are going to go to the difference. Correct or not? Okay. Having understood the importance of will, now I have on the screen, ladies and gentlemen, the difference. Just now I showed you take effect upon death. This another difference between will is will passes through probate just now. Okay, passes through probate. As I mentioned, you have to go through probate process. And when it become probate, when it come probate, it become public record. Right? On the other hand, trust bypasses probate, avoid costs and delays, and it is private and confidential. Right? And confidential. So the other major difference is cost. So when you do trust, it is more expensive initially. A trust can ultimately be less expensive because it avoids probate process, provided it is properly drafted and funded. Right? So you decide, you and your attorney decide. This is from the website I collect, so that you can also go to the same the difference between will and trust. You will see this. I just now giving you indication so that you can go and Google. So you decide which of these two methods is best for you based on your individual circumstances. However, each of these differences should be carefully considered as part of your overall decision. So now, this is the suggestion. So we have to understand what, why, just now, when. Okay, 5W. So this is on the what of trust. So when you create trust, so you begin distributing your property before death. You can also do it, after death, and you can also not giving, but being managed. Your asset being managed after your death. So now you see the expansion of the planning. So this is how it shows. On your screen, ladies and gentlemen. Now I'm sharing with you the methodology. So the person who create the trust is called settler. Settler, or if it is in the will, he become testator. So he passes the property, just now transfer the property to a trustee. Now trustee, you have legal relationship between the testator and the trustee. So Rafie, as an owner of a property, say landed property, it is in my name as beneficial owner, I can also transfer this property to me, Rafie, as a trustee. But here it kind of show that it is another person. But the law allows actually, I transfer to myself, now I become trustee for the benefit of other people. So now I'm not the beneficial owner, I'm trustee for the beneficiaries. So the third person is beneficiary. Beneficiaries where the trustee owes an equitable obligation. So this is created when the owner of the asset passes the legal title, Rafie transfer to Rafie, the legal title to another, to hold on trust for the beneficiary. This arrangement, terms and condition of the trust is covered, will be the term and condition are covered in what in the document what you call as trust deed. You don't call it a contract between settler and trustee. You don't say an agreement. There's you define it clearly. It is term as trust deed. Trust means the trust, deed means the document. Trust deed. So this is generally how it is created. And when this happen, ladies and gentlemen, the trust assets which has been passed to the trustee. So just now I say Rafie transfer to Rafie to hold in trust for Najiha, for the matter. So it doesn't belong to Rafie now. It is to benefit Najiha. But there will be a lot of complication, that kind of thing. So we suggest that if you want to do such a thing, you want to do transfer, you want to do trust, you transfer to a trustee, and you have trustee corporation, for example. There are a lot of trustee companies outside there who can manage, even on the same floor with MFPC. Level 22, you have trustee as well, right? If I'm not mistaken, you have trustee. So the trustee will hold the trust asset. That's right. Trust asset will be managed separately by the trustee per the trust deed. It will not become an estate. It will become trust asset. So it doesn't go through probate process. Nobody knows. That's why we hear a lot of cases on estate. Just now, even when you have a will, the family, fight among each other, that kind of thing. But for trust, you normally don't hear anything, because everything is confidential. Okay, so the purpose of trust is, I have this on your screen now, if you can see that. The purpose of trust is to authorize trustee to manage the asset for the benefit of trustees, benefit of beneficiaries. I'm sorry. Right? Reason? Because the trustee have special skill or knowledge the owner might not have. So interestingly, Najiha, while I was driving coming for today's session, I noticed one billboard, bill on trust or something. Yeah, YNHB, something. They are the owner and property developer for property 163, right in front of this one Montcarrot,
correct.
right? That is built on trust. So apparently, the owner, the creator, the promoter believe in this one. I suspect there must be some trust kind of thing. So the owner probably different, but the trustee may have special skill and knowledge, or for some reason, sometimes you want to go away for some time. I have a client who is staying in New Zealand, and because of the COVID pandemic last time, we actually do not know whether she will come back or not. So she was considering of appointing her sister to take care of the house in Ampang Jaya, condo in Ampang Jaya. So I asked, why we want to do that? Because she says she keep on receiving a lot of bills, all this thing from the and then the management corporation, that kind of thing, and she's not around. Right? No. And if anything happen, because the place where the property is situated may be vulnerable to landslide, that kind of thing. Bukit Antarabangsa, right? So maybe some evacuation, will have to be in order, that kind of thing, for safety. So she has to be around. But because since she is far away in New Zealand, she decided to appoint the sister as her representative. Of course, the sister can deal with the asset and everything, but she is not the trustee. So I advise, maybe for that reason you want to appoint your sister to become trustee. So you have to go back to whenever you come back to Kuala Lumpur. We go to land office in Ululangat. We organize so that you can appoint your sister as your trustee to become the beneficiary, to become trustee for the benefit of you as beneficiary and your son, that kind of thing. So that is even easier because her sister's name will be on the land as trustee. This can be done, right? So ladies and gentlemen, sometimes because you have a special reason, you want to protect the interest of the beneficiary, and when you create trust, this will protect the beneficiaries from creditors' claim. Whatever asset that has been put into trust is creditors' proof. So creditors cannot claim because it is actually not in the name of the owner anymore. It has been transferred to a trustee. But of course, some other issues will be raised, can be raised to say that the trust was created to defraud the creditor, that kind of thing. It is a subject matter of a claim lah. But otherwise, this is what we say: living trust, not part of estate, and be dealt without probate or LA. Trustee can be individual, professional, or trust corporation, and you can give specific instruction on management of asset, and you create a testament trust via a will. Interestingly, over the weekend during Deepavali, if it is not too late, if we have Indian participant, Deepavali Batukal, I wish you all, hope we all safe and benefit from whatever in the future. I met this foreigner, an expat from Germany. He's a German from Germany, staying in Malaysia. His wife is Malaysian. Wife, a property all properties in the name of the wife lah, because he cannot be registered as owner kan, he's a non-citizen. So he was asking me, what's going to happen if the wife pass away earlier than him, predeceased him. So he thought having a will can assist, can help him. But because they are Muslim, I said the provision the effect of a wasiat will be different from a will. You cannot transfer to each other, cross will. No, wife give to husband, husband give to the wife. No, because of faraid law. Okay, so if that is not possible, wasiat is not possible. I propose to him and this family. I propose to them that better for them to do trust. So trust meaning they transfer earlier, they organize earlier, that everything in the name of trustee, right? So I said, I give example. You transfer to me, Rafie. Rafie is a trustee. Rafie hold in trust for you all. They see the different how it will work. But I said that is not a very good advice, because even though I'm a trustee, I'm much older than them. I said 10 years older than you all. I might go first, and then it become difficult. Therefore, I suggest that they appoint trust corporation. So they can appoint trust corporation. All assets, including cash and everything, can be transferred, put into trust account. Then the trustee will manage. As long as they are alive, either one can go first. They are the beneficiary, but must be specific. On the other hand, I said, for example, in the event that the wife passes away earlier than the husband, the husband can remain in the house, and remain in the very expensive condominium in KLCC area. But there must be specific, provision, paragraph to say that not only that the husband, surviving husband can stay, the surviving husband can also remarry and bring the new wife to the house, correct? Otherwise the trustee might block. So that they understand the importance, and hopefully very soon I will be able to assist them in organizing a living trust. So how you create it, ladies and gentlemen? Just now, must be trust deed. It must be expressed, and you can do it express, you can do it clearly, right? And then you can also do it via a will. It become testamentary trust, meaning it take effect only after death. But if you do it while you are alive, living trust, as we explained earlier, it will automatically be transferred, and both parties have got real interest in that. I want to highlight to you, ladies and gentlemen, on the sharing today, the participant, on item number 3 on your screen, on the slide, statutory law. Trust can be created by statutory laws. For example, FSA 2013, Schedule 10. So this is a situation when you have your life insurance protection, you nominate your parents, if you are not married yet, or you appoint your spouse or your children to receive the benefit, to receive the proceed of the life insurance, to receive the insurance money, whatever you call it. You nominate them under paragraph 5 of Schedule 10. You nominate under paragraph 2, paragraph 3, but the effect is stated in paragraph 5 of this schedule. It says that if you do so, say my name is Tan Rafie. Tan Rafie. Rafie have got a will, have got a life insurance. Then I nominate, Rafie nominate dia punya missus, nominate children. The payment of the life insurance proceed will go to this nominee as if this is a trust. It means it is not a estate. No need to go through probate process or whatever. The insurance company must pay to the nominee, and they receive, because it is statutory trust, they receive
creditors proof, because this shall not be become part and parcel of Tan Rafie's estate. It become statutory trust. So this is very important. Today, one of the take backs that you can collect from today's sharing is paragraph 5 of Schedule 10 FSA. Please, ladies and gentlemen, make sure you take the benefit of this law that is available. Okay. While having said that, the importance of trust, I want to share with you that it is also subject to interpretation by law. If you don't properly write, but just now by implication, the slide earlier say by implication and everything, sometimes you have to get clarification. So the court will define, the court will determine. If it is not properly written, not properly drafted, but you think it is impliedly mean there is trust, it is the court who will give proper interpretation of the whatever trust deed or whatever law available. So here I'm sharing with you case 2022 6 loose appeal over businessman family trust, as if there was a family trust created by this businessman. So the court decided, the federal court has ruled that a businessman did not establish a trust for his family members when he drew up an agreement 40 years ago to apportion his share in a company that had his properties. Judge Aminder Singh Dhaliwal said the trust did not exist as the gift by A.S. Dawood, a Negeri Sembilan businessman who died in 89, was imperfect. 1989. He ruled that at no time did Dawood state in his 1981 agreement that he was holding 110 shares in trust for Abu Bakar Rawouf and his 5 siblings, the children from the 4th wife Dawood married in India. This is issue kan India is also a jurisdiction where the law of inheritance is quite established. They know the requirement, and because Muslim can marry 4, right? One of the wives now have got 5 or 6 children, and these 6 children claim that they have a right over that shares in the company because of whatever arrangement that was organized earlier, and the court ruled otherwise. So, ladies and gentlemen, whatever arrangement that you have, the finality will be determined. The determination will be by the court ruling. In case of not very clear provision in whatever agreement that you have. So, ladies and gentlemen, now this is very important. We want to spend a lot more time on Q&A, I hope. So I want to finish this is last slide on that I want to share today. Because of the dispute, if there is a will, and they can be dispute. Even if there is no wasiat, there can be dispute. Maybe you want to avoid this dispute by giving earlier. So on your screen, ladies and gentlemen, I'm sharing with you this new Gazette, Stamp Act 1949, which says that Stamp Duty Exemption Order 2023. It took effect on 1st of April. It says here simply under the schedule, paragraph 1 clearly, and then there we column number 2 donor, column number 3 recipient. So I take, for example, I'm a father, I'm a father, I want to give to my daughter, Najiha, for example, and Najiha has got other sibling, but she is my favorite daughter, my favorite child, no, she has been helping me. I want to give her more because I believe she's entitled to more than the others, and maybe she has much more requirement. Maybe this daughter of mine has got children, my grandchildren all depending. She is probably taking care of the children, who special, that kind of thing. I want to give more to my daughter. So rather than keeping a property, now say that property is being tenanted, and every month, there is a rental of 2,000, for example. Now I receive the rental, and then I take the 2,000, I pass to my daughter. I can start organizing that I give the property right now to her. Now, if I put it in wasiat, the other sibling might not agree, right? They might object to it. Though the intention is clear, whatever, say no. This cannot be carried out because this is a wasiat given to heirs, right? So heirs entitlement under estate, for the estate is inheritance rule of fara'id. So under fara'id, girl get 1, boy get 2 portion, right? So maybe the eldest son say, no, this is not right. I'm entitled to 2 portion. How can ayah give to Najiha? Right? Whatever Najiha is not valid because this is giving to heirs. So, the sibling can object to it. So it will not be carried out. When there are dispute, fara'id law will come into place. In order to avoid that, with this provision now, with this exemption of stamp duty, Rafie can just transfer to Najiha and pay no stamp duty because it is exempted. Alright? Because it is exempted, stamp duty is exempted. I only pay, or Najiha only pay 10 ringgit for the property if it is worth 1 million. Exempt free. Otherwise, before this law, which was approved under budget 2023, and the parliament has approved this, if I want to transfer to Najiha as a father, right, the transfer to Najiha, my own daughter, will attract stamp duty. How much? As an example, 1 million worth of that property transfer to my daughter, stamp duty is 24,000. 2.4, there are calculation to it lah. Stamp duty payable is 24,000 because Najiha is my daughter. Then it become 50% discount, so Najiha will still have to pay 12,000. Right? So there's stamp duty to it. That's why people don't transfer when they are alive, because every transfer attract stamp duty. Right? That is why, ladies and gentlemen, a lot of non-Muslim friends, they do will, because they can provide the transfer via a will. So Mr. Tan Rafie giving to his daughter Tan Li Niao, for example, if Rafie were to give to Li Niao while they are still alive, 12,000 for 1 million. So Rafie said, I do in a will lah, because when I die, you follow the will. When you do the transfer later from the estate of Rafie to Li Niao, of course the other sibling cannot claim, no stamp duty. So last time, to avoid stamp duty, you do transfer via a will, right? Or you transfer via trust. But as I indicated earlier, there's also cost. And the cost is the transfer cost. full stamp duty. So that's why it is costly. That's why people don't do trust. People do via a will. But my final slide that I'm sharing with you, later we take Q&A, is why you wait later? Why you make it as inheritance? Why can't you do it now? So the law has now enabled you. So Mr. Tan Rafie can give to Miss Tan Li Niao, the daughter, now. And no stamp duty involved. If it is less than 1 million. So it is straightforward. Vice versa. Vice versa. If the child want to give to the mother, if the child want to give to the parent. So the schedule is clear. And it is clearer here, it says grandfather or grandparents giving to grandchildren. Vice versa. Right? Vice versa. Right. You see the schedule? It says vice versa. No stamp duty. So this is what, because this is new, probably this require further explanation. We hope then later we will have some more time to explain this new law, because this new law took effect recently, as recent as 1st of April 2023. Right? So I hope, ladies and gentlemen, you will see the importance of having estate planning. Not all, you can differentiate. Will is enough. Trust is not suitable. Maybe it is a combination. Maybe things which you can organize earlier, you organize earlier. Now, having looked at this PUA 178 stamp act exemption, stamp duty exemption. Now I want to give you an example on motor vehicle. Okay, motor vehicle. So, ladies and gentlemen, even though there is no such table like this, no stamp exemption like this, a person who has got a lot of motor vehicle, for example, and then he wants to transfer the motor vehicle to the children. Why delay? Why wait? Isn't it? You don't want to die first and let the motor vehicle, 3 or 6 motor cars in your house become estate. Right? So what do? You organize and you go to JPJ after doing certain requirement. You have to make sure that whoever you want to transfer, say the daughter, is now the recipient of Mercedes manufactured 2018, for example, 5 years ago, fully paid now, model such and such. So you want to give to her, make sure she have she organized that she has protection, insurance for that car. The car will go through Puspakom inspection before 1 month, and you go to JPJ. The father and the son and the daughter just show the IC, put into the system, and with thumbprint, the property will be now transferred to the daughter at the cost of 50 ringgit. No, not more than that. And within 30 seconds, it is completed. Almost 1 minute. You can even start asking question to the JPJ officer. The thing is already transferred. The grant registration card for the car now will be from the father changed to be the daughter's. The road tag also in the name of the daughters. Question. Now that the father has transferred to the daughter, can the father drive the car? The father can still drive the car. It is only registered in the name of the daughter. Under different name, the father can still drive the car. When the father passes away, any time after that, there is no issue of going to court to organize the LA, to organize the probate, because that Mercedes year 2018 is already in the name of the daughter. It is not part of the estate. So if you can see this illustration clearly, then I hope, ladies and gentlemen, you or your client, you can be able to advise your client to do, this is real estate planning lah, to do it while you are alive. Because it is about protection, we mentioned just now, it is about preservation as well as about provision. If you can provide now, property, landed property through this great new law passed by the parliament, you can also do other things. Why wait? Right? That's why just now, very interestingly, Najihah asked about hibah. This is the concept of hibah. People give, but because people are not really fully aware, of the hibah. Maybe, after this, we should do a lot more, awareness campaign on this issue. So I hope, ladies and gentlemen, with that explanation, few slides that I've shared, shed some lights, for the topic that we are discussing today. The topic, asset distribution, the difference, application between wills, wasiat, and trust or amanah, should be beneficial, for our future undertaking. We have time for Q&A, right?
Yeah, sure. We got some time for Q&A.
Okay.
Alright, thank you so much, Tan Haji. I think it clears some confusion or some misunderstandings from our participants today, because for your information, half of our participants involved today are not only someone in the financial industry, but they are also members of public. So,
correct.
Yeah, so maybe it's good that we have these sessions for them to understand more about trust and wills. So, Nazmi Farid asks, is pampasan takaful through hibah valid if the witness is the beneficiary?
Alright, Nazmi Farid must be takaful agent, I suspect. So Nazmi, if you are takaful agent, you don't call pampasan takaful. Okay, you say takaful benefit, manfaat takaful, because we don't pay pampasan from takaful. Takaful is benefit, manfaat takaful. So under takaful, you can nominate recipient, whoever you nominate, as beneficiary, penerima hibah. Then hibah takaful is created. Okay, hibah takaful is created. You go through process, online process via iPad. You nominate. Say example, I am your peserta takaful now, takaful participant. I'm not a policy holder, a policy owner. I'm a takaful participant. I participate in takaful. What will be issued to me is takaful certificate. But I do nomination. So now I nominate Najihah as beneficiary of conditional hibah. That is under the law APKI, Akta Perkhidmatan Kewangan Islam 2013, or IFSA, Islamic Financial Services Act 2013, Schedule 10 as well. Give effect that whatever happened to me, the manfaat takaful will be payable to Najihah, even though Najihah is not my family member. Najihah was my great student, for example. I want to give that manfaat takaful to her because I might be indebted for whatever good deed. So that sijil, 100 or 200,000, now I hibah to Najihah. Najihah takes all. When anything happen to me, Najihah will receive full. My family members cannot challenge, because this is not part of my estate. I have already given hibah. But must make sure when I do the nomination hibah, there must be witness. Najihah cannot be the witness. That was Nazmi's question. Najihah cannot be the witness. If Najihah become the witness, of that nomination of my takaful to her, she will not receive as beneficiary. Cannot be the same rules apply. So I hope Nazmi see that clearly, inshallah. Okay, next.
Then next question is, can Malaysia will be used in overseas?
That I explained already earlier. Alright, Politan, I explained that there are a lot of cases I have done. We prepare Malaysian will under our law, but it can be implemented in Australia. It can be executed in other places where the property is situated. For example, my name is Roger Tan Rafie. I have asset in Hong Kong. I have asset in Singapore. I have asset in Thailand. Example, will is written in Malaysia. The High Court of Malaya give the probate. That probate can be used in Singapore to organize the estate in Singapore, in Thailand, as well as in Hong Kong. That kind of thing. No problem. But must go through the court system. Okay.
So if any of our participants might have missed the earlier session, no worries. We will upload this recorded session on our social medias next week. So
okay,
you
good.
can always watch it whenever you want, no issues.
Yeah.
Alright, so next question is from Miss Logasvati. Tuan Haji, if I handwritten will with 2 witnesses now, let's say after 20 years I die and one of the witness also pass away, is the handwritten will is still valid?
It is valid, it's still valid. But don't have to worry. When you go to court, 2 witnesses required to confirm that this will was signed in front of them. So one of the witnesses passed away already. So the other witness says, yeah, I and whoever or the deceased with me. So must show that the deceased, the other witness is has gone, deceased already. So he won't be able to put up a affidavit in witness. So one affidavit is enough, but you must clarify. But I would like to draw that attention, Logaswati question just now. If you have already written a will and 2 witnesses sign, and then you are still alive, and the witness is predeceased you, you probably want to do new one. Take younger witnesses lah, so that the younger witnesses can go to court and become witness. In my case, not my case lah, whenever I do will for my client, I go with my young children. I go with my son. I have 2 sons. One 32 years old, one is 21 years old, and they become the witnesses. I prepare, the will. My children, 2 sons become witnesses, because you need 2 witnesses, right?
Okay.
So I pay them to become witnesses, so that if anything happen to the client, when I am not around, these 2 sons can file the affidavit in witness to confirm to the court that these 2 witnesses, that we, the witnesses, were there, seeing this is the testator sign right in front of us. So that is the only requirement actually. But if one is not around, the other witness must confirm. So no problem. Thank you.
Thank you for the questions. I think we can have at least 2 more questions before we end our
Okay,
session
okay.
today. Okay, so from Koi
Koi
Muntong, can Muslim hibah his property to the brother while alive?
Yeah. Definitely. Don't be mistaken. Hibah means giving while alive. Both must be allowed alive. Right? So if you want to give to brother, a person has got sons, then the brother is excluded. Muslims say, I've got 2 sons now, I mentioned, because I have 2 sons, then my 2 brothers are not entitled under Fara'id law. They are excluded. They will be stopped from receiving because of the existence of my 2 sons. So they are not entitled. But I want to give that property in the kampung where my brother is cultivating, for example. My brother has been doing the kebun. Though it is in my name, but he has been doing that. and my children probably don't want to go kebun. So I must decide earlier. I tell my children, since you are not going to inherit this, I have the intention of giving to the uncle. If I just say like that, then my brother will not receive. So what I should do is I hibah. I go to the land office, take my brother to the land office and say, no, ni kebun ni 1 ekar ni nak transfer pada abang ni. So sign. Sometimes the DO can give exemption. No need to pay stamp duty because it's tanah kebun, everything not much. They give exemption or pay half or whatever because they are the authority. And then the property now will be transferred to my brother since he's doing the farm. And then this farm, this kebun in the kampung which I have given to my brother will not form part of my estate. Excluded, yeah. It is not my estate because it's not in my name anymore. It is in my brother's name, and that's why you do it while you are alive. So hibah, please do it while you are alive. You don't postpone it. Say, bang, I will give you when I'm not around. You tell the children now, when I'm not around, make sure you pass this property to your uncle. That is my estate. And when it is my estate, it's subject to, the law of faraid. My daughter might not agree. Right? So the uncle will not receive. This is very important.
That's where most of the cases in Malaysia, the family argues about the estate.
Yes, correct.
Right?
The dispute of the Muslim estate mostly around that issue because the father had said earlier. So now the children say we want to honor the father's intention, but it cannot be carried out, right? Because of objection, for example. Unless the father said 1/3 of my estate be given to charity, then it cannot be objected. It will be carried out, inshallah. Next.
So one last question. Okay, maybe you can choose which one you would like to answer, Tan Haji.
Okay, Tan Pek Cheng, very good. The last question we received at 3:55. I think this come from well understood participant lah. If I can now transfer the property to my brother, question is, need to pay stamp duty or not? Answer is yes.
Still need to pay for
it. Because it is not excluded by the stamp exemption. The stamp duty exemption, it is only from parents to children, children to parents, grandparent to grandchildren, or grandchildren to grandparents. Brothers and sisters still attract stamp duty. And that's why a lot of people don't do this. Right? But there should be some means later to organize. Hopefully this stamp will be expanded and include family members, that kind of thing. Hopefully we'll achieve to that stage, inshallah, later. Alright, thank you for that question, Tan Pei Chin.
Fun Suk Chan asked one more question.
Okay.
Alright, would like to know if husband and wife die in a car accident. I heard husband will activate it first, then the wife will activate it later as according in the law. Need clarifications. Okay. The clarification is estate of a person will be administered or will be executed, in this case a will. So we have to know who died first, right? So if they die together, they don't not necessarily die at the same time. They might die together, right? But not at the same time. So the time depending on the time stated in the death certificate. Whoever die first, then his or her will be carried out first. Alright.
Okay. So don't worry about that. The death certificate state the time like this lah. 3:58 3 o'clock 58 second 20 seconds. So 3:58:22. And the husband died 3:59 01, for example, based on the time the doctor fill up the form in the certificate of death, right? So that's why very important. So the certificate will know who died first. If they die together and it happens that the wife predeceased the husband, then the wife's will be executed first. All right. Thank you. I hope that
Thank you
I
very
explained
much,
the thing.
Haji. I hope that's clarify the questions. Okay, so I think we have already come at the end of the session today. It's actually 2 hours full session.
Yes.
Thank you very much, Tuan Haji, and our dearest participants for staying with us until the end of our session. So I hope you guys enjoy our final episodes for this year. And don't forget to follow us on TikTok, Facebook, Instagram for more financial content. So before we end our session, a little sharing of the upcoming event. The Securities Commission Malaysia's annual flagship investor education event is back. The 3-day event starts this Friday until Sunday. And this event will give you an opportunity to learn about how to invest in the capital market wisely. So this initiative is also in collaboration with MFPC. So if you all are excited or wanted to know more, to talk to the consultants for free, don't forget to mark your calendar and visit us at KL Convention Center. So as the saying goes, to every beginning there is an ending. That brings us to the end of this episode of Virtual TeaTalks. So thank you everyone for joining us. On behalf of MFPC, I would like to thank everyone who has been supporting us since day one, and I would like to apologize if there were any shortcomings throughout this event.